if you want to carry on in the meeting, you just accept. So let me welcome you to the first Senior Leaders event of 2021. And before I introduce Alison, we have 2 upcoming branch events that I want to let you know about. Next week on the 16th of February, we've had Head Torch speaking to us about confidence in supportive conversations. And that is a lunchtime session. I think from memory, that's at 1 p.m. And then on the 25th of February, we've got Susan Gordon and Erica Cargill speaking to us about from imposter to superhero. So have your capes looked out for that one. That's a 4 p.m. start for that. But without further ado, as ever, I should say the information on that's on Eventbrite and on the branch website. But without further ado, let me introduce Alison for those of you that don't know her. Alison Woods is co-head of CMS UK employment team and has nearly 20 years experience working with employer and senior executive clients. She works across a range of sectors and has particular depth of experience in the knowledge of energy matters, living and working in Aberdeen. Alison has a strong interest in assisting clients through change, which often sees her advising on business transformation projects and other collective and strategic exercises. Alison is frequently called on to support sensitive issues at boardroom level and works alongside clients in management reorganisations and employee industrial relations matters from design through to implementation. She's also a board member of the CMS International Employment Practice and has a wide experience of cross-border and multi-jurisdiction issues. So that's just a very potted history of Alison. She's telling me she's working on the biggest, and I can't even remember, I'll let her tell you what it is, but it's the biggest project she's worked on across, I think she said 12 countries, which seems quite crazy, but anyway. I'll pass you over to Alison. If you've got questions, if you can put them in the chat box and then we'll come to them at the end. Alison's going to speak for about 45 minutes. But anyway, I'll pass you over to Alison now.
Great, thank you. Thanks for that introduction. I guess it made me smile there thinking that in that short bio, what it doesn't say is that Alison's in tax or immigration matters, and yet that's broadly what we're speaking about today. So you'll forgive me and perhaps be a little bit forgiving in terms of any questions that you do ask, bearing that fact in mind, but very nice to be speaking to you today. So just a recap, I'm obviously not sure how many of you joined the session that we did a year ago, obviously at that stage not knowing what would happen to the world in the coming months, where I talked in some detail about the off-payroll working changes and what was coming. Since then we have had some sort of late amendments to what is going on around these rules, and today, although I will talk about some of the basic issues around it, I'm also largely seeking to pull out where those clarifications or changes have happened. So just as a general recap though, in terms of IR35, for those of you who may be coming to this sort of or needing a refresher, this was introduced in the year 2000, essentially to try and cut down on tax avoidance that was felt to be in place, where if you are working as an employee but have somehow structured yourself not to be in that type of relationship, the idea was that you should still be taxed as an employee. So for this reason, it doesn't affect directly people who are directly engaged. The person who's engaging them already had to make that assessment in terms of how to tax them. But this is where someone provides their services through an intermediary. Perceived high levels of non-compliance was a huge and remains a huge issue for this area. IR35 is essentially felt to be largely ineffective. It relies on going down to those intermediaries themselves. They're the ones who currently carry the liability in terms of any sort of tax or national insurance failing, in terms of the individual not being appropriately classified. And so because of that, that has had an impact both in terms of perceived risk around the issue, with a lot of clients largely not seeing it as something they had to give too much thought to, and also a huge issue in terms of enforcement, given the HMRC have limited numbers of people to deal with these issues, and essentially you were going after one person at a time. So with that in mind, there was a feeling that going the client route, essentially making this a wider sort of compliance issue that businesses needed to think about, would help both in terms of industries then taking it more seriously and being more proactive in managing it, and also helping in terms of enforcement. So we saw it being introduced, first of all, in some shape in the public sector, and the changes which were meant to come in last year and which are currently slated to come in April 2021 will affect well, some aspects of the public sector in a wider sense now, and also for the private sector's purposes, medium and large private companies. So the sort of position there changing for quite a few businesses, as you can imagine. So in terms of what the latest is, people keep asking me, will they delay it again? Will they delay it? We're still in a pandemic. Are they going to sort of stop this happening? I guess largely I've stopped guessing in terms of what the government will do. I've spent a year trying to get to grips with the furlough scheme, apart from anything else, where for a period, I got myself a gin and tonic every Friday, just waiting for the government's latest change in policy or update, because they almost inevitably changed their minds or did something just as the weekend arrived. So will they do anything around this? I can't rule it out, because obviously we've learned to expect the unexpected, but certainly as of right now, there's no stated intention to do anything other than have the changes come into effect from April this year. So we had them postponed already from last year. We've seen, I guess, something that's quite interesting is that in January this year, just looking at the latest update on this slide, a pretty broad survey showed that over half of contractors hadn't had engagement from their client regarding the reform. And I think that's quite interesting. I guess from our personal experience, it is quite interesting that we have had some clients who were very well prepared coming into the postponement last year in March. Others, not so much, I think it would be fair to say. And purely from my own experience, people have maybe been diligently working away in the background, and we've just not seen an awful lot of that. But we don't necessarily feel that the last 10, 11 months have been spent with people really delving deep into projects around this and preparing. So it will be interesting. My suspicion is that there are a lot of businesses still with a lot to do around this. We also have the practical reality, which is because of impacts not just on the oil and gas industry but on the world generally, the use of contractors may in itself have become more limited in a lot of businesses, simply through reduced work or more financial limitations. Whether that has led to a perception that this is an issue that's not as important for businesses, I don't know, but certainly as far as we're aware, it's still coming, and things still need to be done. So what will be happening from April? Well, the big change, as I say, up until now, the can is well and truly carried by the limited company, the intermediary itself. The very big change from 6th April 2021 is that the engaging business, the client, they have to take responsibility for determining the status of the worker that is supplied and communicating that in what's called a status determination statement, so an SDS. Once they have made that status determination, they have to notify that, and the party that actually pays the fee to the intermediary then has to account for income tax, national insurance, apprenticeship levy, assuming that SDS has led to a finding that those deductions should be made. So let's just look, for those of you who came along last year, you may recognise this diagram. So just making that slightly visual, we've got the client at the bottom of the slide. They have a contract, in this case, with Agency 1. Agency 1, though, doesn't have the relationship either with the worker or indeed with the intermediary. They have the relationship with a second agency, and that agency is the one that pays the fee. So the individual who's providing their services, they, let's assume in this case, have their own limited company. That limited company has a contract with agency 2, and it's agency 2 that's paying that fee. So in the case where the client makes the status determination, they need to give that status determination, first of all, to the party that they're contracting with, and also to the worker. Just as a practical point, what we're finding is that quite a few clients we were setting processes up for had arrangements in place to procure that. That was an obligation passed down the chain, essentially, rather than them having to do it directly. And then the agency 2 is the one in this case who's going to have to make the deductions from the fee if that's what the finding is. Obviously, if the status determination reaches a conclusion that they sit outside of this regime, then payment can continue to be made gross. And I'll come on and speak about some of the issues in terms of liability as we move through the slides. I should say that although an intermediary is normally, in our experience and what we're dealing with, a limited company, it's not the case that has to be the case. It could be a partnership. Theoretically, it could be another individual, but our general experience is that 99% of the time we're talking about limited company contractors, as I think we've all come to refer to them as. Something we have had clarification in recent months has been around chains of intermediaries. It's quite a technical point, so I won't go into any great detail on it here, but essentially, because of the way the legislation had been drafted, there was a concern that essentially it could capture things like umbrella companies where deductions were already being made from revenue that was going to the individuals, and there have been clarifications to make sure that there's not a sort of double hit, if you like, in terms of those areas. So we've looked at who is the intermediary, but who is the client? This has been a really interesting issue, certainly in the oil and gas industry, because if you are an operator, just to use the most obvious example, and you are then contracting with large service providers who then sitting below them perhaps have an agency or a couple of agencies, then an intermediary, then the worker being provided, where does the buck stop? Where does the liability sort of reach some kind of ceiling so that it can't go above that? Now, the clarification or the explanation that we have in the legislation is that if it is a fully contracted out service, then you are not the client for the purposes of this legislation. So again, if you're an operator and you have a caterer who provides services to you, and you have a contract with them to provide a catered service, for your office, or at least you did before you partially closed your office, then it's incredibly unlikely, almost impossible to imagine that in that situation you are going to be the client for these purposes, because if that service is fully contracted out, they control the people, they deal with everything that they do, then that's not something that comes back to you. Remembering all the way back to the beginning of the slides, this is really about, should someone be seen as effectively being your employee? And if it's a fully contracted out service, then that's not likely to be the case. There is a brief HMRC guidance note on this, if anyone wants to look at it in any more detail. I think that where it's had our clients scratching their heads a bit more are in the more sort of subtle or confusing cases where you maybe have what you view as being a contracted out service, but what if there are other things that are provided around the edge of that? We've heard many examples of services perhaps for, operations and maintenance, which are viewed as contracted out services, but also under the guise of the same contract, there'll be a number of POs issued for individuals to come in and work in different areas of the business. Is that, are you the client? And in those cases, we've really had to delve down into thinking about, well, are you the client for this part? No, but are you the client for this other part? And so there is quite a big due diligence exercise that needs to happen just in terms of thinking about the nature of the client, the nature of the services being provided, how the relationship is managed. Are these people who come in essentially are integrated into your workforce? and are being, treated effectively like other people in your teams, and given benefits, integrated, managed, and so on. And then there's the practical perspective, which is beyond the scope of this morning's talk, of looking at things like contractual arrangements and liability arrangements with your supply chain. And that's something separately we've been working on a lot with different legal teams, in terms of thinking about, well, if my contractor is trying to give me assurance that they've got this covered, it's all sorted, there's nothing to worry about here, well, who's going to be liable if they've got that wrong, if they've made that decision incorrectly? What should our contract say about that? So lots of issues to think about. Something which has been new relatively in terms of, certainly since the last time we spoke, was the question of how do you identify, or what happens around requests to identify whether someone is a medium or large company, because this doesn't apply to all businesses. It only falls down for those who fall into that medium or large size bracket. So in terms of what is medium or large size, you have to hit 2 out of 3 tests. One is that you've got an annual turnover of 10.2 million or above. Another is that you've got a balance sheet of 5.1 million or above, and the third is that you've got over 50 employees. And those tests are looked at essentially for the tax year, ahead of the tax year. Size requests then, the clarification that we've had just is in terms of whether you can ask your client in the broader sense as to whether they are, are you a small company? Can we assume that we're not needing to think about this? Is this something that's not relevant for us? And it's certainly worth doing in some cases, because of course, if the client confirms that it is small, then it means that the off payrolls don't apply. They don't need to consider those arrangements in this particular case. So we've got much more structure around that now in terms of where those requests come from, the process and time period for replying to them. So let's assume that we're in a situation where a status determination, an SDS, has been made. If there's disputes around that, we've been given additional information in terms of how that operates. So we've got a 45-day period during which the representation can be, during which you can respond to any representations about that status determination. We need to, if you get any of those, if you are the client in that situation and receive a challenge on it, you do need to have a process for considering those and looking at them. As you'll come on and see, a really key thing around status determinations is for us to show that we've taken reasonable care around them, and also that we've complied with this process for dealing with disputes. So it's not something that should be ignored, and I would strongly recommend that you're comfortable that internally there are processes set up to make sure that these things go to the right place and that the people who receive them understand what needs to happen with them. When someone challenges that SDS, that the client needs to consider the challenge that has been made and either confirm that the original SDS is correct, or to withdraw it and replace with the, well, presumably opposite finding. And in that case, you'll see that you need to state when it is you consider that that new determination became correct. So has that always been the case and there was something that you were missing because of a change in circumstance and it's from a different date that you believe it applies? You have to provide the reasoning behind your conclusions. So having a process which is simply that these things come in and we simply reply, no, we're not listening, we don't agree with you, is not going to meet that test. So again, it points towards having processes set up internally. And what's your incentive for doing that? Well, you'll see at the bottom of the slide, if the client fails to meet that deadline and fails to follow that process properly, then they become the fee payer from the end of that 45-day period until compliance is achieved. So essentially, this is one of the ways in which clients can end up on the hook for tax. So it's definitely worth making sure that there is that process in place for that not to happen. Another area which I know was of interest to some of the people who were at the meeting last year, and we didn't really have an answer on it, was in terms of foreign companies and how does that operate in terms of, you know, in what circumstances are we going to be liable in the UK? And we have had helpful clarification around this, which is essentially that there does need to be a UK connection before the beginning of the relevant tax year. So it's not enough to have a sister company in the UK, for example. It has to be in the context of a corporate structure, that there is actually a permanent establishment, so at least a branch in the UK. And looking at that, that's going to mean that there's a fixed place of business, or that there is an agent there who has authority to contract and do business on behalf of the client. If you are fully outside the UK and you don't have those things, then these rules are not going to apply to you. There are obviously still complex tax questions that can arise in terms of the workers that are being supplied to you, and making sure all the tax arrangements are correct for them depending on their circumstances. But on this specific requirement around off payroll, we know now it's dependent on this UK connection, normally in the form of a permanent establishment. So moving on then, in terms of thinking about when is it that a client is going to become responsible for that tax liability or paying those national insurance. And I break this down into the situation, first of all, where the client is the fee payer. So in that situation where you have limited company contractors coming direct into your business, there's no other intermediary there. In that situation, first of all, you need to look at whether, first of all, you've determined that there's an employment relationship. So if you would obviously have to carry out an SDS in that case, because you are the client, undoubtedly, in that situation. If you decide through that they should be taxed effectively as an employee, then you're going to be liable, because you're also the fee payer, to ensure that that happens. The alternative situation is that you carry out the SDS and you don't reach a finding that tax should be deducted, and you carry on paying gross, but at some point HMRC successfully challenge that. So far, so relatively simple. And of course, in that situation, you're going to want to be careful in terms of the basis on which you're making your assessment, so that you limit any scope for that liability. What is more complicated is the situation, and this will often be the case, where you're not the fee payer. So the person being provided is an agency or two down from you. So in that situation, where can you become liable? Well, first of all, again, if we go down the top arm of the slide, and in that situation where you've carried out the SDS, so again, we're assuming here, when we talk about client on this slide, we're talking in the sense of for off purposes, you're satisfied you're the client, because of course, if you're not, if we've decided this is a contract, this is not one for us, then you're not in this space. You're only in this space where you've decided that actually this does come back to us, I am the client for off payroll purposes. So in this situation, I'm not the fee payer, but I have carried out my SDS, and I have determined that I think there is an employment relationship for tax purposes, deductions need to be made. If in that situation I fail to comply with any of these obligations that I have, and some of them have already been mentioned on the earlier slides, then in that case, the liability can come back up to me. So if you look at the right-hand side of the slide, you'll see that, have I maybe carried out that assessment but failed to provide the SDS. Now, failing to provide the SDS includes where I failed to provide it having taken reasonable care. So, for example, one approach that was mentioned by some businesses was to make an automatic default approach in terms of these things, whether that was to treat people as being inside or outside, or to just do a very sort of rough categorization of people. That type of approach risks not taking reasonable care in terms of the arrangements, and even though you might technically have provided an SDS, it probably wouldn't be one that would meet the relevant requirements, and in that case it could mean that the liability for the tax comes back up to you. Other ones would be where you've not dealt with the dispute process within those timescales and giving the relevant information that I've already spoken about. And And the other one is where you have failed to withdraw an SDS and let them know that you're no longer a medium or large business for that tax year. So we are responsible for making sure that we're managing that process where the nature of our business changes. So again, there are so many areas I find with this that, you know, I assume I'm talking to HR people on this call, but off payroll is one of these things. It's not, and if anyone within your business tries to tell you this is an HR issue, it's not. It does affect HR, but it's a business issue. It's something that touches on various different parts. Different parts of your organization will have things that they need to do to make sure this is happening correctly, and there are ramifications if they don't. The other situation then where you're not the fee payer, where you may become liable as the client, and you'll see I've got a box there with a red cross through it. That's not accidental. So underneath the red cross, the text says that you've determined that there's no employment relationship, but HMRC successfully challenged that. So in that situation, you'd think, well, that's quite similar to where we were the fee payer, and that's right. But there was a concern around that, just in terms of, you know, how would that work where there is, you know, a business below us where we have, you know, given our determination, we've done our bit, you know, can that really always come back up to us? And they have just failed to, as a fee payer, take account of tax or do what they're meant to do around that. So in that situation, there's been clarification, and the reason for the red cross is that you as the client will only be liable in that situation where you have failed to take reasonable care. So if you have taken reasonable care in making your status determination and you have said, we think you can carry on paying gross, we don't think this person falls inside the rules, and that is then the arrangement that's put in place, but HMRC later successfully challenged that. The clarification now is that you as client are then off the hook. That shouldn't come back up to you. Now, again, outside the scope of today's session, but it might strike you that there's some interesting issues that can come up against that, because if the agency or the party in the chain who is paying the fee has set up, you know, they're paying gross. They've not held any money back in a piggy bank to pay for tax if this goes horribly wrong. That creates some interesting dynamics, just in terms of, well, who contractually is going to pick up that liability? So the client might be saying, not my fault, I did it with reasonable care, and you know, nothing for me to do here. Whereas the agency might be saying, well, now I'm sitting with a big liability for tax because as the fee payer, it's come back to me. Who can I go against to get that money back? So again, highlighting it's not just an HR issue. We see contractual issues coming up in terms of we maybe need to think, okay, this is what the legislation says, but how does that flow out in practice? Who's going to be responsible for that in that situation? So depending on, you know, sometimes you might find you're a client, sometimes you might find you're a fee payer. So you might have different perspectives on this, but definitely worth making sure that the business is thinking about that in terms of what sits behind these arrangements. In terms of recovering pay and arrangements from agency one, so in this from the client and agency one. So agency one would be the, if you look back at the diagram, the party that we have the contract with, and in that diagram it was agency two who actually paid the fee. So there has been provision within the legislation that if there is tax due and the fee payer is not paying that, then that they can crawl up the chain and get that tax and recover that, and essentially say we're putting our clause into agency one and potentially all the way up to the client as part of that. And that's, you know, you'll see from the top of the slides what HMRC are able to do. The clarification that we've had, and I think what is really important, is that HMRC have now said they will not seek to crawl up that chain and recover that tax in that way, where the failure is due to a failure to account is due to a genuine business failure. So essentially, we're not responsible for the success or failure of other people's business. in terms of whether they ultimately pay that tax or not, which I think is massively important and was a real concern for people further up the chain prior to now. And of course, while I've mentioned a couple of points here, contractual arrangements and liability arrangements in contracts, it's not much help having an indemnity from an agency if that agency simply goes out of business. And I think what this touches on in the rest of this slide is really a point around due diligence. I think this becomes around this way to avoid this passing up the chain is where there is genuine business failure, but essentially the business has been doing its best and doing what it ought to do. You'll see from the bottom half of the slide that HMRC are not ruling out the possibility for them to look into these arrangements and crawl back up the chain if they actually feel there's been some sort of tax avoidance. So if essentially you've contracted with an organisation that is consciously playing fast and loose with these type of arrangements, and perhaps have even been selected for that purpose to get round this, then HMRC are clear that we could go back up the chain. And so, we're strongly encouraging that this really, and I think it's maybe something I mentioned last year anyway, that a lot of this liability regime forces you, I think, to think quite seriously about who you're contracting with, and being satisfied, as to how they're setting up their own arrangements, that they're doing things properly, because by them doing that, that's what gives you comfort that if, unluckily for them, something goes wrong, it shouldn't come back to you. Whereas if actually they are not running their business in the way that they should, then actually that also in turn exposes you as the party further up the chain. So that's in terms of liability, but we've spoken about the status determination statements. How do we actually determine employment status? And we're back to this CEST tool that I spoke about last year, and this is the government tool. It continues, I think it's fair to say, to have a number of people, and probably quite a lot of people, quite frankly, who are critical of it and don't believe it does a good enough job. We've heard again and again that the government are going to continue to refine the tool, and so it's not the finished product even now. And maybe it will not ever be. Maybe it's going to be something that's going to continue to need to be refined. The great advantage of CEST has been and continues to be that if you use CEST and follow what CEST tells you, then essentially, provided you've taken reasonable care in doing that, that is your sort of get out of jail free card in terms of being allowed to rely on that. It's not the only way to do it though, and critics point out the fact that CEST is all well and good, but when a CEST type approach is tested in the courts, the government has a much patchier success rate, and there are a number of private organisations, you may be working with some of them, who take the view that essentially their tools in a more sophisticated way look at the reality of different arrangements and setups. So it's really for each organisation to decide what they want to do. It depends on your appetite for engaging with limited company contractors at all. It partly depends on how you want to engage with your supply chain more generally on these things. Any tool that is not CEST will not come with the comfort of you being able to rely on it in the same way. But there is a concern that too much reliance on CEST, some parties feel, will almost end up that you're always going to be falling foul of the rules somehow and requiring to deduct tax in every case, which effectively can lead you to a feeling that we're not effectively able to continue using limited company contractors in the same way, and that may not be attractive either. So it should be a really measured decision. It's interesting to run the CEST tool over some of your cases, even if you're looking at using other tools to understand where they come up with different results, and discussing that with any provider you're working with, so as to understand how that sits, how that works. Also, if you're working with any provider in terms of them using a different tool, I think it's very important. I've spoken about due diligence already today, but looking at due diligence there, you know, well, if they get it, if their tool gives you a result that is then successfully challenged, what do they say about liability? How does that work? We know there are insurance products out there, IR35 off payroll insurance products. Read the small print, understand how that's actually going to work, rather than just, you know, the headline or what the policy is called. You know, in what circumstances will it actually protect you? So project planning now, hopefully you're all sort of well into project planning, or even beyond project planning, and you're at project implementation. But again, you know, worth reminding others in your business that this is not just an HR issue. You know, we need to think about legal, we need to think about procurement, the people who actually be engaging with the businesses. You know, we need to combine that. I mean, another one that should be on there is, you know, I guess operations, that, you know, the mainstream business itself, they will certainly have views. We've had some clients who've taken a view that actually will just not engage any limited company contractors going forward, essentially tried to sidestep a lot of this stuff on the basis of we'll just make it not relevant for us, but then have come into a situation where from an operations perspective they've quickly been told that's not feasible. There's going to be exceptions to that. There are going to be reasons we need to use limited company contractors. So there's no point developing an approach which is not stress tested and doesn't fit the business that you have. So, you know, there are choices in that approach. I'm not going to go into the detail of that today. I spoke about it last time, but, you know, you need to decide whether you are going to continue to use contractors and simply have, you know, processes in place for doing that, whether you're going to try and move certain types of services to being contracted out. You need to think about the approach you're going to take to the contracts with your supply chain. Lots of decisions to be made. It's not that there is a single answer here, but that planning needs to happen. To the extent you've not already done so, you really need to do an audit in terms of understanding, you know, what your starting position is. And something that we've identified with some clients is if you essentially downed tools in March last year, you may need to look at this again now, because the starting position you had then might have changed. And with the focus away from off payroll during that 12-month period, it may well mean that while you think actually we really slashed back the contractors we used during that period, that may not reflect reality now. So worth going back and just checking where you are with that. And then once you're carrying out your project, don't forget in terms of awareness and training, or you know, being comfortable that someone's taking care of that in the business, because you know, you've seen already just from some of the sort of brief points that I've mentioned today, there are obligations that are going to fall on the different parties during any of these relationships. They need to be understood. The people who are encountering these things need to at least be able to spot those points where there's action that needs to be taken. So having the processes, having the awareness and training is really important to make sure we're doing that properly. So that is a whistle stop of some of the latest changes around the off-payroll rules. The other thing, nothing like covering two difficult topics in a very short session, but the other thing I was going to speak about briefly were the implications, or high-level implications for HR around Brexit. And I'm really just going to look at the top-line immigration points. Hashtag I'm not an immigration lawyer, so please no difficult questions around that. Looking at the possibility for employment law changes coming, and finally just, you know, what does, to the extent you've seen the trade deal, the very last minute, you know, beyond the 11th hour agreement that we got before Christmas, what does that mean in terms of future changes and what can happen? So just going to canter through a few things on that. So in terms of timeline, obviously 2020, none of us will be sorry to see the back of it, is gone now. And you know, I think Joe Public, generally, a lot of people really didn't understand that actually Brexit had happened a year before that, and we just had been in a transition period for 12 months up until 31st December last year. And with everything else going on, you know, one concern is whether people really did fully understand everything that they needed to do up ahead of the end of that transition period. And from an immigration perspective, the key thing was the rules are going to be different, or are different, depending on whether you entered the UK before or by the end of the transition period, or, and I've just realised there's a typo in that, it says 31st January, it should be 31st December, my apologies. So the transition period, did you come in by the end of last year, in which case you're in under one set of rules if you were an EU citizen, or did you come in from the start of January? So for those people who arrived here by the end of the year last year, they are able to apply under the EU settlement scheme. And the good news for those people is that even if, hopefully, though a lot of those people have already applied and been dealt with under the settlement scheme, but even if they didn't, we have this extended deadline until 1st July, where it's so long as you were in by the end of last year, you can still make an application under that scheme up until the 1st of July this year. On the other hand, if you only came in to the UK from 1st January onwards, then it doesn't matter that that scheme is still open for new applications. You can't apply because you were not here by the 31st of December. So that date is really important in terms of which rules apply to you. From the 1st of January, we've got the new immigration scheme for people who came in. That's also the scheme that will apply if for some reason there is someone who is here from the EU and doesn't make an application by the 1st of July, then they will equally, it doesn't matter that they've maybe been here for years and years, they will equally have to be treated under the new immigration scheme. So I guess one practical point within your business is are you comfortable that everyone who should have applied under that scheme has done so? There's still a window of opportunity to do that, but we are now talking about the new scheme otherwise. In terms of that settlement scheme, I'm not going to go through the detail of it today, but essentially 5 years you get settled status, less than 5 years you get pre-settled status. In terms of doing that. So what's the new scheme though? Well, it's a scheme that's based very much around a lot of the rhetoric that we heard around, ensuring that there could be that Britain was open for business and we could have skilled workers and we were opening up the global workforce marketplace to the UK. That's essentially the kind of basis on which the process has been implemented. So now people will have to have a job offer to come in. They'll have to have that, at sort of A level and up in terms of equivalence, and they have to show that they can speak English. There's still the salary threshold, but at a reduced level. It will be a delight for anyone on this call who has to deal with immigration matters that the resident labour market test is going. And the other thing that is going is the limit on what was tier 2 in terms of the number of certificates of sponsorship that were available. That is going. So there is, interestingly, in terms of a lot of the noise around control of our borders and people coming in, actually there is, in this sense, uncontrolled immigration now with no sort of cap on the number that could potentially come in. But the point about that is that we're saying that it's skilled people coming in with jobs who come into the UK. There is a specific route for low skilled workers. Obviously this is quite a political point in terms of some of the jobs that have in the past been fulfilled by low skilled workers in the UK, and how sustainable that's going to be. It's a political hot potato. Wouldn't be surprising if that comes back as being a topic for further debate. But in brief summary, the position has been the suggestion that people use UK workers for those roles is essentially the answer that has been given. So in a very sort of summary terms, I would say that bringing people in from the EU is going to be more expensive than it was before, not necessarily more difficult. The process, is going to be the same whether people are from the EU or outside the EU, and it's a simplified process. but remembering that up until last year we didn't have to do any process for those people and could simply treat them in the same way as UK workers, then of course it is an added layer. And so if your business is reliant on bringing in a number of people from the EU, it's going to cost you more money. If you are a business that's looking to take advantage of, or already was looking to bring people in from outside of the EU, I guess the answer is that it's not particularly any more expensive because you're already having to go through a process with them. And in fact, it's going to be easier to recruit with the absence of the market test and the lack of the ceiling on the number of certificates of sponsorship that can be issued. So, you know, that I guess is what is the upside of the new scheme. And then in terms of lower skilled workers, it is going to be harder to recruit. So if you had anyone at that, you know, absolute lower end in terms of the skills and the income level, that is no doubt at the moment creating challenges for you. Now, an interesting quandary has arisen, which I don't, I'm afraid, have a good answer for you on this, which is around right to work checks. You're all no doubt aware that it's a requirement for businesses to support in preventing illegal working, and essentially if you don't by carrying out right to work checks, you give yourself a statutory defence that even if someone ultimately turns out not to have had the right permissions to work in the UK, if you have done what you ought to with your right to work checks, it means that the company is not liable for that. So because of that, businesses generally carry out right to work checks on everyone who comes and works for them. The difficulty is, and you'll remember that I spoke about this window between, you know, whether when people came in, was it by the end of last year or not? We're left in a sort of very difficult situation where the Home Office has said that right to work checks won't change until the end of June. So, you know, when we're hitting that deadline of the ability for people to continue making the applications to settle here. But of course, in the meantime, when you're recruiting people into your business, how are you meant to know whether they came into the UK before? You know, you may happen to know because of certain, you know, I guess things on their CV or other information they share with you, but how do you generally know whether they are someone who is under the new scheme, in which case we're looking at the new immigration requirements, or actually are they settled in the UK or still in a position where they could make an application to settle in the UK. And employers have been left, quite frankly, in a pretty difficult position on this, because there's a, while the Home Office is saying the checks are not, the requirements around those are not going to be changed. On the other hand, if you don't carry out the check, if you simply rely on seeing people's passports, as you would have done for EU workers previously, then you run a risk that actually you're not doing everything you ought to identify whether someone actually has the right to work in the UK now, and you could get yourself into difficulty in terms of, you know, potential prosecution if there is someone who is effectively an illegal worker. So there is a bit of a dilemma there in terms of what you do and how you approach this, possible discrimination risks in terms of targeting people from particular countries and putting additional requirements in place for them just now, where the Home Office are saying that the checks aren't being changed. So, you know, it's something I would suggest, you know, if that is impacting your business in terms of bringing people in, certainly in the coming months until the summer when we see that change, is something I would suggest that you take further advice on to make sure that you're comfortable with the approach that you're or as comfortable with the approach you're taking as you can be. The next thing then, obviously the big question, or so many big questions, but a big question has been around what happens? Do we keep EU law, all of this legislation that we have, including employment legislation? Do we actually keep that here? You'll be relieved to know I'm not going to take you through all the detail on this slide, but it's partly there just to show you the complexity of what was needed in terms of transitioning out of the EU from the perspective of legislation and laws in place. Fundamentally, for you as HR people, the key thing to understand is that the legislation that was put in place to enable us to leave the EU actually has the effect of saving that legislation. So it allows the UK to essentially replicate that legislation and keep it in place. And on the 1st of January this year, after the end of the transition period, there was no change. It's not suddenly that any law falls away. So unless something explicit happens going forward, the position continues that we keep the legislation that was already in place. Now, there's a separate question, an interesting one, about moving forward and what happens in terms of any new legislation or things like that, and that's what I'll come on and look at now. So first of all, on case law, UK courts are generally bound by what's called the doctrine of precedent. So that means that the reason that we look at what the Supreme Court or the Court of Session perhaps said on something is because an employment tribunal, a lower court, will be bound to follow what a more senior court has decided previously. And that remains the case. And so where there is these precedents which arise from the European Court, those will continue to bind the UK courts going forward. So, in some ways, nothing should change. But there was provision in terms of the arrangements that there was a power to depart from that doctrine where it was, in inverted commas, right to do so. Now, that was a right that was generally conferred only on the UK Supreme Court and the High Court of Justiciary in Scotland, but it has now been extended, including to the Court of Appeal in England and to the Court of Session in Scotland. So just to give you an idea of the layers, if you have an employment tribunal case in Scotland, it will go employment tribunal, employment appeal tribunal, then to the Court of Session, and then from there to the UK Supreme Court. So what this essentially means is that it opens up the possibility of case law starting to diverge, essentially. There's a greater opportunity for those judges in terms of looking at issues as they move forward to start to identify circumstances where they feel it is right for them to do something else rather than simply follow the EU case law. And that's quite interesting because some of the sort of naughty issues that we have, not naughty as in terrible, but naughty as in wood issues that we have around EU type legislation at the moment come from situations where there's been a bit of a conflict between what seems to be in the UK legislation and what the EU court has then said. So classic example, holiday pay. Our legislation points towards, a week's pay for a week's holiday, and a week's pay is determined by what's in the Employment Rights Act. That then has been sort of, torn apart essentially in some cases by the case law, which has said, well, no, a week's pay, because of what the European Court says, has to mean what a person actually would have earned. Now, we therefore think, and we're not alone in that the areas that are probably most at risk of being impacted by this are those ones where there's been that sort of slight difference already in terms of what might have appeared to be the UK approach and then what has been imposed on us. So things around changing terms and conditions under TUPE, which the UK government has always historically wanted more flexibility around, dealing with holiday pay, those things may be more vulnerable to challenge and are probably the ones to watch in terms of future cases and things that happen. But do remember that this is not something that you do something about just now. We're talking about cases that could take years to progress to the appropriate levels. And particularly because of the pandemic, in some parts of the UK, there is a significant delay in terms of cases making their way through the courts. So it's all very fascinating at the moment, but certainly I don't think you need to worry about changing your policies or approaches for quite some time yet. Data protection, just in the interest of time, I'm just going to sort of skim past, but essentially just to say that we are now, or would have been, a third country. We're not part of the EU. We don't just get to pass things around as we did as a member of the EU. We've essentially been given an additional window because of the trade agreement. A 4-month window could go up to 6 months, so that they can hopefully look at us and decide that we get a tick in the box of being an adequate country, which will make life a lot easier for passing data to and from the UK. But meantime, you really do need to think already in terms of, even at a basic level for HR, your privacy notices. What do they say about information and where it's passed? Are you passing information to EU countries which you didn't really think about before, but now you need to think about on what basis are we going to do that? So do pick up data protection as being an issue that affects you in HR as well. And then finally, just on the trade and cooperation agreement that was entered into, well, it does affect the future of UK employment law. One of the conditions was that this, and where we got to, and this was certainly not the thorniest issue, but it was a thorny point, was obviously the ability to make the UK, a better place for business, more flexible place for business, would have been attractive to those who really wanted Brexit. But from an EU perspective, to give us a trade deal, they wouldn't want it to give us some kind of unfair advantage in terms of how things were dealt with. So this level playing field concept has been included in the trade agreement, which is to avoid either side, although I think it would probably generally be felt it was the UK would be more likely to do this, to take advantage of sort of undercutting employment standards and therefore having unfair competition there. There's a responsibility for each side to ensure there are mechanisms for enforcing that. So, having courts and tribunals that deal with all of these issues. And then you can see here on this slide what the actual playing field type provisions are. So we need to ensure that we don't reduce the overall level of protection for workers or fail to enforce those in relation to those 5 areas that are set up on that slide, sort of, fundamental rights at work. Now, the devil, no doubt is going to be in the detail, just in terms of this doesn't mean that we can't make any changes to employment laws in the UK. It certainly means that we couldn't rip up what was already there. And I don't think particularly that would have been most people's expectation in any event. But there is a little bit of scope there for some changes again to come through. There was suggestion of an early review to look at areas of labour law and what might happen and what the government might do around that. There seems to have been a quick U-turn on that for now. So we'll be left waiting to see what the government decide to do as time moves forward, and no doubt some interesting times ahead. So thank you. I think I've gone slightly over, but hopefully not too much, and I hope that was interesting.
That was super, Alison, thanks. Hazel's going to manage the questions that came up in the chat, so I will pass over to her.
Right, that's better. I've done the typical virtual meeting error of speaking away without put my mic on mute. I'll just quickly go through some of these. The first question there, and it relates to IR35. What if you have a company that is formed of lots of different small companies, what is the criteria for small, medium-sized companies?
Yeah, so that's a good question. The assessment as to whether you are small or not is based on group level. So if you are part of a group, you're going to need to look at that. So you can't avoid this issue simply by putting employees, for example, and you need to look at that group level.
Okay, that answers that question. That was me that raised that question, so that's fine. Thank you. Question from Jane here. Is there an obligation to repeat the SDS, the status determination?
Yeah. I mean, I guess in effect, yes, because there's nothing in the legislation which requires it to be done at specific intervals, but essentially it's an ongoing obligation so long as the services are being provided. So certainly in terms of discussing procedures and processes to be in place within businesses, we've been speaking about how would you set yourself up for success in terms of being able to identify where perhaps circumstances had changed such that that might no longer be accurate? Now, you know, these things are probably an art more than a science, and also perfection may be the enemy of progress in terms of, you know, how exactly you do that. But I think certainly, particularly if you're making fairly generous use of limited company contractors, you will want to build into your arrangements how you do check that any SDS that has been given continues to be appropriate.
Yeah, and I suppose things do change over time. So it could well be that you started out with somebody outside the IR35, but because you've integrated them within the company, that could change. So I suppose there is definitely, you need to keep an eye on it moving forwards. Right, I'm looking, and how far back can HMRC go to getting tax and NIC monies due if they challenge an SDS?
Oh, I think there's a specific answer to that, and I don't know it.
Okay.
Certainly quite a few years, longer than I would want to have to pay the tax for.
Yeah, because I think there was a couple of high-profile cases linked to TV broadcasters. Lorraine, she got that she got away with it because it was very specific.
She didn't get away with it.
Oops. I forget I'm speaking to a lawyer there. Okay.
Yeah, for years, yeah.
Okay, I think we've answered Kathleen's question about the definition of small or medium-sized companies. It's 50 employees, but it can be a group amalgamating several different companies. This one here, if we've got time, it's a question from me. I've used the CES tool quite a few times to give you some specific detail. Offshore, we use rope access supervisors. They have a particular skill, and we need, if we're doing any rope access work offshore, we need a rope access supervisor, and we hire them in as a single person limited company. And when I've done the CEST assessment, it always comes up as undetermined status. And I think that's purely because we have to provide all the equipment. It's all quite closely controlled. But is it, I mean, you can't obviously redo the process again until you get the result that you want. So what would you recommend we do if we get an undetermined status?
Yeah, so that is one of the, certainly not the only criticism of CEST, because it's one of the criticisms of CEST is that there is a level of cases that you will get an undetermined answer to. I mean, obviously, it undermines the benefits of CEST as a tool for you in terms of the point I mentioned about them being able to rely on the action that you take, because you're not going to have that determination. You still, unfortunately, even though it doesn't give you an answer, it obviously also doesn't mean that you get away with not having to deal with the legislation. So you still have to take reasonable care at that stage in coming to your own assessment. So I think that at that stage, that's probably where it comes down to either from your own knowledge or taking specialist advice, deciding what side of the line do we fall under. You know, you're identifying there some particular circumstances as to why you do certain things. That might point you in the direction of saying, well, perhaps us providing equipment would normally, you know, in a kind of, you know, generic situation be something that would be something that would lend itself towards the employment side of the fence. Maybe in our case, we feel that that's not the case, because we can explain that and there are particular reasons. So, I mean, ultimately you have to fill that gap yourself as the answer and use reasonable care. So I think it's about documenting and having a basis on which you're then filling that gap and making that decision. Some of the providers out there will say to you that they will always manage to come to a decision for you, applying their approach. So I'm certainly, I care not whether anyone uses or doesn't use any sort of, external provider for this, but that might be one reason that you want to speak to a party like that if you are coming up against it a lot, because it might be worth you speaking to a specialist if this is the type of contract you're taking on several times, getting a bit of advice which you then know you can use if you're then replicating that on multiple occasions.
Okay, thank you. Right, I think that is all the questions now. Oh no, one from Kathleen. Do you have to keep, and that's regarding non-UK employees settled status in the UK. Do you have to keep an employee settlement status on file? How long for? I know from my own personal experience, you get a code, it's dead simple to do. The individual has to get a code which they give the employer. You go on the government website and it spits out details for you that you can download and save on file. But how long do you need to keep that for?
Well, you need to show you need to show that you did the right to work checks before someone started working for you. But generally speaking, in terms of the evidence that you keep about someone's status and their right to work in the UK, we generally recommend it's kept during their employment and then for a period beyond that in case your paperwork needs to be audited. So.
Okay, and then I've got a query that's come in here from Craig. I'll just read it out. I know the examples used in presentation are potentially generic, but if operator A employs catering company B to do offshore catering, who in turn engage a chef, if that chef is a limited company, should the operator be worried that they could potentially be liable for tax and NI?
I was just trying to draw myself a little diagram as you were giving that example. I think that in that situation, if the operator has a contract with the caterer to provide catering services, then and if in terms of those catering services, it is for the catering company to decide how those are delivered in the same way as the onshore equivalent. And we're not controlling that, we're not supervising the individuals or doing anything around that, then it sounds to me as if it's reasonably likely that the operator could treat that as contracted out service, essentially, and so that the operator would say that they were not the client in that situation. So as with answers to any questions on these things, that's just based on what I'm seeing here. I'm not saying it's impossible for it to be different, but as helpful an answer as I can give just now, that's what it sounds like to me.
Okay, and I think we're sort of running out of time here. What I suggest, I've got one more question. Is it discriminatory to ask existing employees who are non-UK nationals who've been in the UK for 5-10 years to obtain settled status or the code so that you can check for settled status?
This is the one, and this is probably where I do give a lawyer's answer and say that people probably need to sort of take some advice in terms of their particular situations and what they want to do. But this is the tension that currently exists in terms of what you're doing with right to work checks, in terms of what the government setup is, but also what your liability is under the current arrangements. In terms of right to work, we're being told that we don't need to check for current EEA employees, so people who are already employed by you. And the right to work requirements generally before someone starts working. And I think there are discrimination risks in terms of targeting particular groups of employees around these things. But equally, against that, we have seen businesses who are, have had, very clear campaigns with EEA employees to offer support, and even facilitate and pay for them to have any sort of, advice they need to help them deal with that process. So, many employers will find they've already been having quite open conversations with employees. But I think that it reaches the height of risk around it now in terms of new employees coming in where we don't know what their history is and what they're doing. And as I say, that's where there is a tension at the moment for the coming months.
Okay, I think that's all the questions there. I can see that there's quite a lot of people leaving now. So I think if we can draw this session to an end, I don't know, Jude, do you want to sum up?
Yeah, that's it's super, Alison. Thank you so much. I was actually quite surprised how much I remembered from your first presentation. So that gives me hope. I'm also, I have to say, extremely relieved that I don't have to deal with this on a day-to-day basis. So I take my hat off to all my generalist colleagues who do. Super information. Thank you again. We have recorded the session, so that will be made available, providing that you're okay with that, Alison.
Yeah, no problem.
And again, I really appreciate giving up your time. Thank you very much for doing that. And for everyone else, nice to see you. Nice to see so many faces, actually, because it is nice to be seeing people. But take care, everyone, and we'll see you again soon, hopefully.
Thanks, everyone.
Thank you.
Thank you. Take care.
Bye.